Good morning and welcome to this RTPI EIA webinar. I think this is a reflection of the strange times that we're in, but also the opportunities we have to effectively go global. I hear there could be about 120 people all attending all at the same time, which is brilliant. We've got a packed programme this morning. I think there's a lot to talk about in planning at the moment anyway, and EIA I think is certainly going to be a big issue going forward as we look at potential inverted commas simplified planning. So I think there's a lot to talk about. We've got an interesting programme today with both public and private sector views. A few points of housekeeping. I'll introduce myself first. I'm Timothy Crawshaw. If you cut me through the middle, it says urban design, I guess, but I'm a chartered planner and currently regional chair of the Royal Town Planning Institute in the North East. And the speakers I have today, I have Rob Murfin from Northumberland County Council. I've got Sophie Gooch, Principal Planner at Fairhurst, and we have Joe Cottin, Associate Environmental Planner from LUC. You're all muted, basically. If you've got questions, what we're going to do, we're going to have the presentation, then a chance while something's really fresh in your mind to ask a question. And then at the end, we'll have some questions as well in a panel discussion because it might get a bit wider than that. So you will be muted. If you've got a question, put it in the questions box. I will try and gather those questions up. And then, if there's a theme developing, I will ask those questions on behalf of you. So without further ado, I would like to introduce you to Rob Murfin from Northumberland County Council, where he's the Director of Planning. Previously, positions have included the Chief Planner at Sheffield City Council, the Derbyshire County Council, and Rob is a former Director of Planning Officer Society, and this year has been elected to the Policy Board of the Town and Country Planning Association. He has a long history of involvement in strategic economic planning, and he has contributed to the development of planning policy and practice in England, Scotland, regional government, and Germany. So I give you Rob.
Good morning, everyone. As Tim says, unusual times. And we're going through some unusual times as well in the world of planning in terms of the white paper and Brexit. So I want to talk about environmental impact assessment, not in terms of an analysis, but in terms of a route map to how you can use it. And I think a lot of what I'll be saying you can use in lots of other decision-making frameworks and appraisal approaches. Okay. As a quick introduction, EIA came into being really in planning in 1988 when I was starting on my last year of my degree. So I studied it, and since then, well, I've had a career with EIA in the backdrop. About 1,000 EIAs are produced in the UK at the moment in terms of planning. Are they useful? Do they help decisions? Okay, the planning white paper will change things. And actually, a no-deal Brexit could change things. So, but these concepts I'm talking about are of wider use. Okay. What I would do if I were you, when you're either preparing an EIA or using an EIA to make a decision, is to look at it from two perspectives. First of all, procedural effectiveness, the extent to which you've followed the formal procedures, and importantly, the extent to which the EIA has helped you make a better decision, both in terms of designing your scheme for submission or appraising it from the planning authority's perspective. Okay. The EIA process really is a structured way of gathering information, involving people, helping determine whether it's acceptable or not, inform mitigation, and frame your conditions. Okay. But the decision-making process is a more value-based, choice-based approach, looking at alternatives, the different weight, the different best benefits and costs, the role of trade-offs, including, I would say, critically upstream and downstream interventions in the environment. And that then plays into discussions about the wider three legs of sustainable development. And that's something which has really changed over the years in terms of EIA, and it's become part and parcel of SD. So hint number one is don't conflate the two issues of process and decision making. Okay. So, the starting point has to be, I know what most people think about EIA, either in secret or they articulate it. And it's about having loads and loads of technical documents. An aside here is always avoid what I call separate chapterism. An EIA isn't a series of separate chapters. It should be read as a whole. Okay, I know you all think, and I used to use the phrase is that if you printed out 4 sets of copies of an EIA when it was submitted to the council, it should always be as tall as your placement student. I think we've moved on from that, but there is a perception, that EIA is about delays and that need to reconsult if you get additional information in. And also, to be clear, EIA, when we talk about the ambulance chasing public interest lawyers who are looking to mount judicial reviews, EIA is often the first part they look at and how you followed it. Okay. What's EIA meant to do in the decision then? And I'd always talk about rationality here, and the basic principle coming out of logical positivism is that the more information you have, the more a rational decision will be, and that you can carry through using information, use logic, and get to the right answer. Okay, but let's be clear, decisions are often based actually on out of field issues, and it isn't just what the evidence is telling you, but also be aware of that, work around it. Okay, so my second real hint is never use EIA to post rationalize commercial decisions, okay, because people will see through it. So in other ways, the EIA should always be freestanding, and it shouldn't just be used to justify a decision you've already made. I know in practical senses, that's often a driver, but it shouldn't be the case that an EIA is just an attempt to give a seemingly rational justification for the true explanation of why you've made a choice. Okay. Hint 3, where you can see this most clearly, and I've seen this over the years, right from the early onset of use of EIA, is how you look at alternatives. Alternatives should really be practicable, feasible, reasonable, viable, and not just straw men to put up there saying, we're not going for a high, we're not going for a low, we're going for this scheme. Okay. So I always say to developers, an alternative isn't just doing the same scheme in a different location. It could be doing a slightly different scheme. And if it's, say, 1,000 houses, you could look at 2 schemes of 500 houses on 2 separate sites. So look properly at the alternatives. A hint, and this is in my notes you'll get a copy of, a good case on this is the extension to the Brands Hatch racing circuit, where the extension to it was deemed to be the only reasonable alternative, and that involved the loss of ancient woodland, I seem to recall. So there is case law about the use of alternatives, but really look at this. If I had one hint at this stage, focus on meaningful alternatives. Okay, consultation. I know you all often think that you have to consult on the EIA because you have to. Remember though, development management, as I keep saying to my politicians, isn't a democratic process. It's about issues. Okay. So what you are doing when you are consulting on an EIA is looking for verification and the triangulation of assertions made within it. Okay, and I'll come back to this later. Okay, so frame your consultation and the way you ask people questions, to try and drag out the verification to whether the EIA is robust. Okay, so if it comes in the EIA and it's correct, let's use a shortcut there term, how do you actually use it in the decision? It is like looking at the planning balance, but it's with more structure. So I'd always suggest looking for messages it gives you about things like environmental synergies, where those separate chapters have influences on each other. I would always be aware that EIA fundamentally comes from a conceptual thinking from the ecological sciences. And keep that in mind, because it was introduced, remember, let's take it right back to the beginning. It was introduced because economic interests were seen as overriding environmental interests, okay? But we have a situation now, you'll have information from an EIA which comes from concepts based in ecological sciences. It gives you an overall view of the environmental impact. But you can't just set that against economic evidence, because economic evidence isn't put in the same scientific way in the planning process. This is probably, a subject for an entirely new or different presentation. But economic evidence tends to be more based on anecdote and forecast rather than science. Okay, so think about carefully the EIA, scientific advice versus other bits of evidence, let's call it, in the process. Okay. A hint for you all, and this may work best for the private sector and applicants. Think about what I call the screening shuffle. If you're going to de-risk a major project, it may be worth thinking about doing a voluntary EIA to avoid huge delays later on. Because, to be clear, remember, you can always ask the local authority to re-screen at any time in EIA and say it doesn't need it. So that's a useful tactic, and it's a useful way of covering yourself. Okay. Right. Well, I'm limited in time, so I'm going to give you some what I call now the most key issues. Okay. Right. How do you actually use the EIA in the final decision? Okay. What you need to be doing is actually looking at, I'd say, 4 questions. Is the assertions made by the applicant in the EIA actually supported by the evidence? If there's real harm coming out of it, the lack of alternatives or the existence of alternatives can be enough of a reason for refusal. Okay, bear that in mind. So, to be really clear here, when you're doing normal planning decisions of any types, you can look at the issue of alternatives, right? In EIA, you are compelled to look at alternatives and treat them seriously, okay? Finally, the big question, which we don't tend to look at enough, is the mitigation proposed in the EIA, in the application, enough or focused enough? And I'll come on to that at my final points. Okay, right. This, if I ask you to take one thing away from my presentation today, and that's after the Brands Hatch decision, that's, again, this is in my notes, it's Dover District Council versus CPRE Kent versus China Gateway International 2017. This is the requirement for a local authority to take various steps in actually making the decision based on an EIA. And applicants need to be aware of this, because you may need to hold the hand of the local authority to get to this. Okay, a big failing potentially in EIA is the failure to provide a clear statement for the reason for your decision. Okay, lots of authorities aren't doing this still, and it's a real area of potential challenge, and it's also poor decision making. So let's be clear. For making a decision on an EIA-based scheme, and this is set out in the regs, or it's signposted in the regs, is a clear consideration of whether planning permission should be granted, the information to accompany decisions, and the duty to inform the public and Secretary of State of decisions. Okay, the local authority must reach a reasoned conclusion on the significant effects and integrate that conclusion into the decision. This argues for including the committee report in with your decision notice. Okay, but where this really bites is that you need to be unambiguous in your committee report and say it in bold and underlined that you've come to the conclusions about the potential significant effects of the development on the environment, and that you think that the conditions of mitigation and monitoring measures are sufficient to address that. Okay, so what you need to do, right, and this is hint number 1 from me, in that final committee report, you need to say somewhere unambiguously that because of the triangulation you've done with statutory consultees, the public, and other specialists, that you consider the EIA is robust enough to make this decision on, okay? And you need to confirm how you have come to that conclusion. In other words, that you have triangulated that with consultation responses. And if you've picked anything up, you have sought for more information. The reason why you have some more information is to enable you to come to the conclusion that the EIA is suitable enough. It isn't just a tick box exercise. So applicants with local authorities who aren't experienced should hold a hand over this. Okay. So in other words, you need to structure the entire EIA process to end up with this point. The last point I want to talk about, and this is if things change because of Brexit, the planning white paper. There are lots of things happening out there, and biodiversity net gain, which again is another topic for an entire talk, introduces lots of metrics to how you look at offsetting impact, and it uses lots of language in a pretty half-hearted way from the EIA regs. And what it does give you, though, is a way of measuring on a consistent way the mitigation that you are tabling against the impact. So I would suggest for all of you as well to read the advice that's emerging on biodiversity net gain, because that needs to dovetail into your thinking about EIA. You know, just as an example, we've run through some of the figures, and if, for example, if you lose a area of woodland on a development scheme and you want to replace it with some low-grade arable land to be planted up for trees, you could be looking at things like a 10-to-1 ratio of higher amount of land required. Well, that's a good way, though, of doing that test I mentioned earlier about is the mitigation in the EIA suitable enough. It gives you a way of actually putting, numbers to that assertion. Okay, thank you. I've tried to keep it to 15 minutes, but my notes have links to all these issues I've mentioned, and it cites the cases as well. Thank you.
Thank you, Rob. It's odd, isn't it? You can't have the applause when it's like this, can you? Shall we try it? Should we try some applause? Yes, thanks very much. On that last point, Rob, there's been no questions coming from the floor as yet, but on that last point around biodiversity net gain, I mean, clearly part of the message in that is that, well, you should be keeping the woodland if at all possible, shouldn't you? Because
it is.
The consequence of,
Yeah, and I would recommend people to look at the biodiversity net gain provisions, even though they are in drafts still, effectively, because that's an attempt to look at mitigation effectively through a series of metrics. And obviously every site is different, and no ecological mitigation calculation will work, easily. But it is in there. But basically it says, it's the size of the issue that you are losing, it's how distinctive it is, the condition it's in, the connectivity it has with human activity, and its strategic significance. And I think that's a useful way of thinking about EIA as well.
Yeah, thanks for that. That's cool. Brilliant. Okay. Well, thanks very much, Rob. And we'll like you to join us for a panel discussion shortly after we've heard from Sophie. So I'd like to introduce you to Sophie Gooch, Principal Planner at Fairhurst. Sophie's a Principal Planner at Fairhurst, working from the Newcastle office. She has a mix of public and private sector experience, with particular experience in environmental planning, along with a sound knowledge of development management, planning appeals and planning policy formation. Sophie has 12 years experience as a planner, as a chartered member of the Royal Town Planning Institute, chartered environmentalist, and a full member of the Institute for Environmental Management and Assessment. She currently leads the major projects team within the Planning and Development Division at Fairhurst. The major projects team are responsible for project management of all planning and environmental issues related to the implementation of major infrastructure and development projects, and the team prepare and coordinate environmental impact assessments and secure planning permission and environmental consents on various development projects, ranging from minerals and waste planning applications to marine developments and accompanying environmental assessments for mixed-use developments. So, Sophie.
Thanks, Tim. Thanks for that introduction. I'm just going to share my screen and show you a presentation now. Hopefully everybody can see that. So I wanted to talk about EIA in the marine environment. Tim, can you just confirm my screen is shared, because it is coming up differently?
You can see it here, yeah. Thanks, Sophie.
Okay, great. So EIA in the marine environment interfaces with terrestrial planning. This is something Fairhurst are involved with, where we have EIA projects that fall both under the marine EIA regulations and the town and country planning EIA regulations. And I wanted to look at today the marine EIA legislation, the interface specifically with terrestrial planning and terrestrial EIA legislation, the similarities and differences between the two sets of regulations when it comes to screening EIAs and also scoping EIAs, and then have a look at what this means for ES production. And I will talk you through an EIA case study just to demonstrate how projects are and can be taken forward under both the marine EIA legislation and the town and country planning EIA legislation. And finally, I'll just summarise with a few challenges and lessons learned when we're working in this marine and terrestrial interface. So in terms of the marine EIA legislation, the key piece is the Marine Works Environmental Impact Assessment Regulations 2007, and they were amended in 2017. As I talk through the differences between screening and scoping and ES production, you'll see that whilst they somewhat mirror the town and country planning EIA legislation, there are some differences to be aware of. In terms of the interface then with terrestrial planning, it's quite a handy diagram that I've seen in a number of presentations previously that I wanted to share with you today. Effectively, if we look at the green line, that's the jurisdiction of the Town and Country Planning Act, and that goes out to the mean low water boundary. So equally, the Town and Country Planning EIA regulations cover that area. And the purple line is the Marine and Coastal Access Act. So all projects in the marine environment that need a licence fall in this area, and that goes up to mean high water springs. So the interface that I'm talking about today is this area between mean high water and mean low water. Where you have an EIA project in this area, you'll need planning permission, you'll need a marine licence, and you'll also need to undertake an EIA under two sets of regulations, the Town and Country Planning Regulations and the Marine Works EIA regulations. So in terms of screening then, essentially the information for EIA screening requests that the developer or the applicant needs to provide isn't that different to terrestrial planning. I've set out the information from Schedule 2 on this slide, and you'll see from the highlighted text in red, there are only slight nuances in terms of references to charts and maps rather than plans, and the development is referred to as a project rather than a proposed development. But effectively, this is the same information that you need to submit to a local planning authority when you're requesting a screening opinion, as you would submit to the marine management organisation making a screening opinion. And then similarly for scoping, the following is required for marine EIA scoping, which is set out in Schedule 4 of the EIA regulations. And again, as you read through this, it's quite similar to what we're used to submitting for scoping requests under the Town and Country Planning regulations, with again some slight differences in terms of the references to regulated activity and project rather than development. But terrestrial scoping essentially requires the same under Regulation 15. So that's from the applicant side and the information you need to submit under screening and scoping. When we're looking at the regulators side, there's a few more differences in terms of how the Marine Management Organisation and a local planning authority will deal with screening and scoping requests. So for screening, marine EIA screening, the Marine Management Organisation needs to provide a response within 90 days. Now that's equivalent to around 13 weeks, which is quite a bit longer than terrestrial, where the local planning authority should provide a response within 3 weeks. And under both regulations, you can request longer periods, but under town and country planning, it is limited to 90 days. So you can see right at the start of an EIA project in this interface, you're potentially going to have a lot longer time to receive a screening response under the marine regulations than you are under town and country planning regulations. For scoping then, if your project is screened in and an EIA is required, and you go through the scoping process, there is no statutory timescale in the marine EIA regulations, although consultees do need to be given 28 days to respond. So again, we can see that it's likely to take longer to get a scoping opinion when you've got consultees given 4 weeks, and then before and after that, the regulator needs to make their own determination. In comparison, terrestrial EIA scoping is a 5-week process. An important point to note, I think, is that you can't appeal a screening opinion from the Marine Management Organisation. There is provision in the Town and Country Planning Regulations to request a second opinion on screening from the Secretary of State. There isn't that provision in the Marine EIA regulations. You can obviously go back in with a second screening request, but you can't go to a higher authority to get an appeal decision on that. So moving on then to ES production and producing an ES under the Marine EIA regs. Happily, there is a Schedule 3 in the Marine regs, which largely mirrors the Town and Country Planning EIA regulations in Schedule 4. And I've set out paragraph 1 really to talk about the main differences. Under the marine regulations, for your environmental statement, you need to provide a description of the project and the regulated activity, including details such as location, size and nature of the project. That's very similar to the Town and Country Planning regulations. Points 1b and c are then more unique to marine projects, where we're looking at the quantity and nature and source of materials, both to be removed from the environment and deposited in the environment. And that just really mirrors the fact that under the Marine and Coastal Access Act, you need consent to remove material, i.e. dredge it, from the marine environment, and also to deposit or construct anything within the marine environment. I haven't then set out the rest of Schedule 3 because in essence, it mirrors Schedule 4 of the Town and Country Planning regulations. So the environmental statement needs to look at alternatives, cumulative impacts, indirect and direct effects, and talk about the duration and longevity of those impacts in the same way that you would for an EIA in the terrestrial environment. So what does this mean in practice? I wanted to talk through a case study, and this is a project that Fairhurst have been involved with over the last few years at St Mary's Lighthouse in North Tyneside. It's a tourist site, it's a lighthouse on an island, and we were brought in to the EIA coordinator for the project. That was my role. When we were brought in on this project, it had been determined that an EIA was required, and the project had been scoped with the local planning authority as a terrestrial development. When we had our first project meeting, the project description was being discussed in terms of works to the lighthouse, and actually the local authority wanted to take forward works to the causeway, and the causeway goes right across the intertidal area through designated European habitat and obviously represents marine work. So we therefore advise that the project should be re-scoped under both the Town and Country Planning EIA regulations and the Marine EIA regulations. So we produced one scoping request covering both sets of regulations and submitted that to both the local planning authority and the Marine Management Organisation. And at that point, we really started working with the officers at both regulators to try and get those timescales that I talked about previously aligned so that we could get a scoping response back in a reasonable time frame. Also, producing one scoping request and one scoping document facilitated the later production of just one environmental statement. And we have done projects before where we've produced an environmental statement under the marine EIA regs and a separate statement under the town and country planning EIA regs, but there is then quite a lot of duplication, and it also means consultees who would be consulted under both regulations would have two documents to view. So it's much better in my view to do one environmental statement covering the marine regulations and the planning regulations. And a really easy way of doing that is just to have a table at the beginning which sets out where the different elements of each regulation are addressed in the ES. It's worth noting that under the EIA regulations for marine works, the need to undertake publicity falls on the applicant. And so in this case, Fairhurst were responsible for placing a site notice, arranging for a press notice to be placed, depositing copies of the statement in a library, all the things that a local authority would normally do under the town and country planning EIA regulations. And therefore on site at any time you had two site notices up, which is duplication but is required under both sets of regulations. And we also made sure to have meetings with statutory consultees. In part at the beginning, this was to make sure the same consultee, the same person from each organisation was consulted on both the planning and the marine licence, so that we weren't getting a potentially different response from within different organisations. And then as the project progressed, this was to help ensure that we had consistent conditions placed on both the licence and the planning permission. And we worked with the local authority and the marine management organisation to review those draft conditions. So then in terms of challenges and lessons learned, I think as I've gone through today, you can see that there are differences between the EIA regulations and additional challenges when you're working with projects in this interface and working under two sets of regulations. There's additional things that you need to take into consideration, different responsibilities on applicants and developers that we all need to be aware of. Obviously, the big difference and one of the biggest challenges for developers is timescales. There's more certainty with terrestrial planning where there are statutory timescales set out in the legislation than there are under the marine regulations. In terms of topics, there is obviously the potential to need a wider EIA project team. So, for example, under the you may have, are we okay still? Yeah, under the town and country planning regulations, you may have an ecology team as part of your EIA project team, and when you're working in the marine environment, you may also need an aquatic ecology team, for example. Duplication, which I've touched on, there is the potential for this, but it can be minimised through the way you present your ES. There are potential conflicts as well, and it can be helpful, as I said, to liaise with statutory consultees on both the terrestrial and the marine side. Helps everybody be aware that there is one project and ultimately to try and get a coherent decision and a coherent set of conditions for developers at the end of it. And as I've discussed, there is a risk that you may get different or indeed conflicting conditions through the marine ES process and the planning ES process, but this can be offset by reviewing draft conditions with both the marine management organisation and the local planning authority. The final thing I just wanted to note in terms of lessons learned, it's always worth checking if the local authority area that you're working within is signed up to the Coastal Concordat. And this is a document that just gives the local authority and the marine management organisation scope to agree a lead authority, both for screening and scoping, and then also in making a determination on the environmental statement. And it can be quite helpful in organising a lead for dealing with the process and having one point of contact for developers and applicants. So that's it from me. Thank you for listening, and we'll see if anybody has any questions.
Smashing, thank you, Sophie. That was fascinating. The first time I don't know very much about marine planning, so yeah, it was a really good insight. Just before we move on, there's been no questions that have been proposed yet, but I'm hoping for some later on. this coastal concordat, how common is that in terms of local authorities? Are there many doing it?
No, it's sadly not that common, and particularly not in the North East.
Mm.
Durham, for example, are signed up to it, I think. But the principle of it is helpful if you're having discussions with the local authority or the marine management organisation to say, okay, can we sort of informally adopt this and have one lead authority and one point of response to try and streamline the process, really.
Yeah. Well, hopefully more then, it seems
Hopefully,
a very
yes.
sensible thing. Yeah. Well, there seems to be more going on out to sea, doesn't there, with renewable energy and things like that. So, you do get that
There's
sense.
a lot, yeah.
Yeah. Definitely. Lovely. Thanks very much. That's great. So, and we'll move on to our next speaker. So our next speaker is Joe Cottin, Associate Environment Planner at LUC. Joe Cottin, BSc Honours MSc MIEMA CN, is an environmental impact assessment specialist with over 10 years of experience across the public and private sectors, including project management of numerous complex projects involving large multidisciplinary teams. She has a thorough understanding of the EIA planning process across a range of development types, with a particular focus on renewable energy and associated infrastructure. Jo has been involved in the project management of EIAs from feasibility through to discharge of planning conditions, and her role includes EIA project management and coordination and the production of screening and scoping reports, as well as the environmental statement environmental impact assessment report. Jo has also undertaken and project managed a considerable amount of environmental statement review work on behalf of local authority clients, and Jo is a full member of the Institute of Environmental Management and Assessment and a chartered environmentalist. So I give you Jo Cottin.
Thanks very much, Tim. Can you hear me okay?
Yeah, I can. Yeah.
Yep, you can hear me okay, great. And you can see my screen, just checking.
Yeah.
Everything's working
as
it should be. Fantastic. Thank you very much. Well, good morning, everyone. I'm actually based in Glasgow, and I was very much looking forward to a trip to Manchester for this event. So hopefully at some point in the future we'll get back to doing these things face to face. But in the meantime, good morning from a fairly rainy and grey Glasgow. So the company I work for, LEC, just to give you a little bit of background, we are a planning and environmental consultancy with in-house skills in EIA and planning, obviously, and as well as that we have in-house landscape architects, landscape designers, ecologists, archaeologists, and graphics and visualizations specialists. And just to note as well, I appreciate obviously quite a lot of listeners, from what I could tell from the delegate list, are from a kind of local authority background. My background is very much from the consultancy side, so that's obviously what I'll be speaking to today, but hopefully some of it will be useful for you as well. So I'm going to cover mitigation in EIA from design to delivery. And I'll be covering regulatory requirements, definitions and distinctions, and also will give a practitioner perspective. So some key challenges that I've faced personally and that often crop up on EIA projects, as well as some top tips to try and address these. And I should note as well, as I mentioned, I'm based in Glasgow, so the majority of the projects that I work on do tend to be in Scotland. So where I have made references in the slides to regulations, they are to English town and country planning regulations, but there may be the occasion where I mention EIA report. If I say that, that means environmental statement. It's just that's what we call an ES now in Scotland, following the implementation of the 2017 regulations. So EIA report, ES interchangeably. So it's just to note that there. So in terms of the regulatory requirement to consider mitigation measures in EIA, as I'm sure some of you will be aware, or a lot of you will be aware, it's set out in Schedule 4, which states that the ES must include a description of the measures envisaged to avoid, prevent, reduce, or if possible, offset any identified significant adverse effects on the environment, and where appropriate, of any proposed monitoring arrangements, for example, preparation of a post-project analysis. That description should explain the extent to which significant adverse effects on the environment are avoided, prevented, reduced, or offset, and should cover both the construction and operational phases. There are a number of other measures to mentions of mitigation within the regulations, including importantly in relation to obviously decision notices and screening of EIA. And that's a whole other presentation, I think, in itself, but just to note here, and I will mention this again later on, that mitigation measures can be proposed and adopted at the screening stage to effectively screen out a development from EIA on the basis that these measures will be in place and will be effective, essentially. So in terms of guidance, I'll cover some other guidance later on, which is Scottish specific, but I think provides some quite good definitions. But this is what the guidance on environmental impact assessment from gov.uk says in relation to mitigation measures. So it doesn't say a whole lot, actually, as you can see there. And obviously I'm not as familiar with the English side of things as I am with the Scottish stuff, but yeah, there's not an awful lot to go on there. You'll be able to read that yourself, but mitigation measures proposed in an ES are designed to limit or remove any significant adverse environmental effects of a development. So it's a fairly straightforward definition, as we've also got in the regs themselves, and goes on to say that local planning authorities will need to consider carefully how mitigation measures proposed in an environmental statement are to be secured. So not an awful lot there to go on. So that's some fairly comprehensive definitions, though, I think, in the regulations and in that guidance. But just to cover some other definitions as well, because I think this is quite interesting and can potentially be a little bit confusing, because there's no clear consensus in the guidance that is available from IEMA, from Scottish Government, which obviously, as I say, is the one that I'm most familiar with. And I just thought it'd be useful just to include here some of the terms that you might come across when reading an environmental statement, or if you're coming on the practitioner side, that you may have potentially used when preparing one yourself. So the mitigation hierarchy, I think hopefully most people will be familiar with. So that's what is effectively referenced in the regulations. So the idea is that you want to, where possible, avoid effects where you can, reduce them, remedy, and then mitigate or offset, compensate those effects. The IEMA guidance, EIA Guide to Shaping Quality Development, which is from 2015, so it's a few years out of date, but it's not, it's not really old. It talks about primary, secondary, and tertiary mitigation. Now, these terms they're not terms that I have, generally speaking, come across. So you may well have come across them if you're, regularly reviewing environmental statements that come across your desk, looking for planning permission. But personally, I find these terms a little bit confusing. It's primary or inherent or design mitigation. So that's set out in this IEMA guidance as modifications to the location or design made pre-application. So they're part of the project, don't require any further action. So that could be reducing the height of a building, for example, and that's what you're applying for. Secondary or foreseeable actions are those which might be imposed through the planning permission, or inclusion in the environmental statement itself, so specific measures identified to reduce the significance of effects, but would require further action once you're on the ground constructing. And they would generally be managed through, for example, construction management plan or something like that. And this last one, tertiary or inexorable measures, actions that would be taken irrespective of whether you did an EIA or not. So that could be standard practice for pollution control, for example, which would have to be done whether you had an EIA project or whether it wasn't an EIA project. So as I say, that those terms are not ones that I typically use or have generally come across, and I think potentially confusing maybe to some. And my preference is actually to use the terms embedded mitigation and additional mitigation. So embedded through design and through good practice, and then additional mitigation measures which are identified as you go through the assessment and you find you might have a major or a moderate effect, and where you think actually we need to do something further to mitigate that effect. And I'll come on to that in a little bit more detail shortly. So embedded mitigation. Now, I've just put a couple of quotes up here, which I think are quite useful. So this is from the Scottish Government Planning Advice Note on EIA. And to me, this is the whole point of EIA, right, is iterative to design to avoid effects on the environment. So, and this really advocates that, as you can see, EIA can lead to improvements in design, including the integration of mitigation measures, and early action to embed mitigation measures fully into the project at design stage is undoubtedly one of the most important in ensuring the full value of EIA is realised. And I think that sums it up really for me. That taking sensible measures at the outset and just assuming that they are in place, as I'll talk about this in the next slide, but it's basically this is what EIA is about, for me. So embedded mitigation, as I said, that can really be a number of things. So, oh, sorry, I went through to there. So can be through design. So designing to avoid sensitive features, as I said, reduce the height of a development, or it can be, I do a lot of work on renewables and grid infrastructure, so routing an overhead line to avoid a sensitive area of woodland or particular feature or habitat, something like that. So that's embedded, it's upfront, that informs where you're going with your project. And effectively that's kind of, when I talked about the IEMA guidance, that's the primary mitigation that they refer to in their document. It can also be micrositing, so thinking about the types of projects that I typically work on. So, for example, a large-scale wind farm or an overhead line project, you would have generally a 50-metre micrositing tolerance, which means within that area you can, you say this is where we think we're going to put the turbine, but actually when we come to construct it, it could be within 50 metres of that. And it's ensuring at the EIA stage that you have undertaken your survey and assessment to allow for that process to take place once construction commences on the ground. And this last point in relation to good practice measures, this is really important actually. So in addition to the design and the micrositing and all of the stuff that you do up front, our standard approach to assessment is to assume that when we're doing the EIA that good practice construction measures, for example, and adherence to industry standards are in place when you do the assessment. So that could be things like, the example I've got there in relation to hydrology, so treating and attenuating runoff from a construction site to ensure it doesn't obviously wash into watercourse, cause pollution, kill all the fish, siltation, all of these things. That's a very standard measure that would be in place kind of without any question, you know, that is a very standard thing that would be in place in any construction site. And these kind of measures are very well understood. They're known to be effective, and undertaking the assessment with those in place, it's just a much more proportionate way to do your EIA. So taking the example of a hydrology chapter, if you didn't assume that you were doing all these standard measures, it would be like Armageddon. You know, there'd be people are just going to come and dig holes, and you know they're not even going to pay attention to what they're doing. They're going to be chucking things in the river, making a big mess, and it's just not a realistic scenario. And then that leads you to having an environmental statement that's full of significant effects prior to mitigation. You can't see the wood for the trees. You can't see what actually are the effects that are an issue where you need further mitigation, which I'll come on to. And it's just a much more effective, proportionate way of doing your EIA. And you know, to come back to one of the points that Rob made about you know, chapterism and having huge EIA reports, and it's really about being proportionate, and that's definitely something that IEMA, who's our regulatory body, are very much in favour of. And just a sort of side note on this as well, in a large-scale grid project that I did recently, we had a bit of a set to with our legal team who were trying to convince us that we needed to do this kind of Armageddon scenario, and basically assume that nothing was in place, no good practice, no standard measures would be in place, and we had many long and drawn out discussions, but we eventually brought them around to our way of thinking. So just a side note there to practitioners, don't be scared to challenge your legal team, because yeah, they're not always right. No offense to any lawyers in the room. So just next point, additional mitigation measures. So as I said on the last slide, this is where you have assumed all your good practices in place, and actually you get to the nitty-gritty and you identify that actually there might be a significant effect on habitat, or using this example of a hydrology assessment again. So for whatever reason, perhaps during a survey, you haven't been able to identify the location of supply pipe work or something, you couldn't get access or speak to the property owner. And so your mitigation then would be to do monitoring before and after construction, and also to go and do the detailed investigation to confirm exactly where that pipe work is, so you're not going in and trashing it and just, causing adverse effects, and then provision of alternative water supplies if it turns out that you need them. And this, it's important, I think, to note just that this is a balanced approach to risk, which again I think is fundamental to the preparation of a robust and proportionate EIA, going back to this point about proportionate and not wanting to assess loads and loads of effects that in reality are never going to happen. And that's in line with, as I mentioned, IEMA's guidance on delivering proportionate EIA, which assists in identifying significant impacts which might realistically, and I think the point is they're realistically arise, and how they could be mitigated. So in terms of delivery, in drafting an environmental statement, there needs to be a very clear commitment to what the mitigation is, how it's going to be delivered, by whom and when. And that's definitely something, if you're looking at an environmental statement that comes across your desk, look for that information. We, generally speaking, provide a schedule of mitigation, which would be like an appendix or something to the environmental statement, where you collate all the mitigation measures from all the chapters of your ES. That could be the embedded stuff, so design and everything, and the construction good practice stuff, and then the additional stuff on top. So it's very clear what's been assumed, what's additional, and it's all in one place. And then that's helpful as well for planning authorities, because they can use that information to inform the planning conditions, which obviously is the way that the mitigation will be secured. Going down the line then, actually, when you actually get onto site, to incorporate that into the construction environmental management plans, then a lot easier as well, because it's all there in one place. And then generally these things are live documents that can be updated as you get onto site and do detailed SI and that kind of thing. And the final point on monitoring, just to note that monitoring is a requirement of the 2017 EIA regulations, but it's just thinking about, if you're going to be monitoring, making sure that if you request monitoring as a planning authority, that it's what are you asking for and why. So monitoring quality of habitat or something, okay, that's all very nice and helpful, but who needs that information? What's going to happen to it? Is it just going to go in a report in a pile somewhere and nobody's ever going to read it again? So just to be very clear and precise about what you want to be monitored and the purpose of that. So just to kind of sum up then, some of the challenges, as I mentioned already, some of the technology can be a little bit confusing potentially. And as I've just spoken about, just making sure that there's a clear commitment to implementing mitigation if you're drafting it. So talking about measures will be implemented, not should be implemented, or it is recommended that these are implemented, because obviously clearly if there's no firm commitment to that, you can't be sure that it's going to work or it's going to happen effectively. And then delivery on the ground, so translation into the consent conditions, and as I've just spoken about, monitoring to ensure that they are implemented and also effective. And just to sum up then, hopefully just about to time, so top tips, really just be clear about definitions at the outset, really. So as I mentioned, there's a few terms that are potentially confusing, overlap, but it's not an abstract concept. Be clear about what you're assuming and at what point it's going to be in place effectively. And looking ahead to kind of when things actually get on the ground and something's got permission, writing things in a way that could be easily translated into a planning condition or similar. And as I mentioned, having that separate schedule of mitigation is very, very, very helpful. And I know that that's helpful from our point of view because it's all there in one place. It's helpful from the planning authority's point of view because it's all in one place. And it's helpful when they get on the ground in terms of translating that into working documents, CMSs and that kind of thing. And then just, final point, as I mentioned at the outset, just to remember that mitigation measures can be used at the screening stage to effectively screen out the need for doing an EIA. And that is me.
Brilliant. Thanks, Joe. That's great.
Thanks. Thank you.
Smashing. Oh, that's lovely. Well, thanks very much. There hasn't been any questions submitted as yet. What I'd like to do is bring the panel back, though, for just a quick wrap-up discussion, if that's okay. Get everybody back. And is Rob appearing? Where's Rob? Hi, hey Rob. Right. Okay then. Well, thanks for coming back, panel. I hope everybody found that interesting. There aren't any questions from the floor, so I'm going to propose we have a discussion about something that came to mind when I was listening to Joe's presentation, which is there seems to be a diversification in systems and approaches, whether you're north or south of the border, and to what extent do you feel that's going to get worse, considering what's cooking and the fact that obviously newts are preventing absolutely everything. So I don't know whether anybody's got any views on that, and pessimistic or otherwise.
Can I just start off here? It's and I think when you look at the planning white paper and you hear government announcements, I think there's a bit of a what I call cognitive dissonance happening out there, in terms of they seem to be holding two mindsets at the same time. When you look at things like the biodiversity net gain, and you look then at some of the messages over design quality in the planning white paper as well, and then set that against the idea that this is going to be issues dealt with at the outline stage or the plan stage, on things like the impact on ecology and other environmental issues, it's hard to do that without having proper worked out schemes in advance in front of you. I suppose the only opportunity would be, and that's why it's interesting about the messages about agreeing mitigation up front from the Scottish system, is that if you would have to, I mean, all this sounds like that making plans is going to be inordinately difficult and time consuming if we're not careful, to have to look at these issues up front. But then again, perhaps we are used to that. It doesn't seem to be that long since the government introduces the requirement for plan level viability work, and that seems to have been now conveniently forgot about as well.
Insights there. Anything from Joe or Sophie on this emerging situation?
Yeah, we do work across the border as well. So, I mean, looking specifically what I was talking about, you've then got a separate set of marine EIA Scottish regulations and terrestrial EIA Scottish regulations, which have their own requirements and things. But also looking at this mitigation and front loading, it sometimes is difficult to advise developers to commit to mitigation when you're just at the screening stage. They might not have even done all of the surveys and things that they need to do to inform that mitigation.
Yeah.
So I love the idea of it, but in practice, I think we're yet to screen out an EIA with mitigation in place at the screening stage.
I think that's, yeah, no, absolutely. And like I said, I mentioned it very briefly there, but that's a whole other webinar, I think, on its own. I also haven't had experience of screening out an EIA on that basis for that exact reason. How do you know what the effects are if you've not done the surveys and knowing what the measures you need to put in place?
I have a really practical question here. If you are going to introduce mitigation and then that screens out EIA, what happens if you run through this process, you get your planning permission, and then you say, because of a problem over land ownership agreements or whatever, you can't implement the mitigation? Surely the permission granted without the EIA then should be quashed in the courts. Does that make sense?
It does make sense. Yeah, I mean, I suppose from a practical point of view, that kind of also goes back to that point about monitoring and follow-up. So, you know, it's not just like it's been screened out of EIA, they've got the permission, and then off they go, and you never hear anything about it again. You know, it's that follow-up monitoring requirement, but how easy or realistic it is to do that for, you know, obviously local authorities are stretched and consultees are stretched, and it's I think definitely be challenging.
Yeah, I think it's a job to ensure that mitigation that's written in a screening request is then carried through to an actual planning decision and put through as
and I would add to that, if you're in the game of if you're doing like the project management on a really major piece of capital investment and you want to de-risk it, both in terms of time scale and the robustness of the eventual decision, I can see that most people, you know, will want to make sure that they are not leaving in late surprises in the process, and therefore probably won't want to screen out of EIA for that reason.
Yeah.
I
mean,
and that's a point, you know, perhaps I will go into more detail in my talk. And I've had lots of experience where a way of doing the time management on this is actually it probably doesn't quite need EIA, but the cover the risk it might need it halfway through the process. So take a step back and saying, well, are there any studies, particularly seasonally dependent ones, I should be doing anyway as a step in de-risking the delivery of a project? And then you've always got them if it is screened into the EIA later on. And if you're talking about a scheme north of £100 million capital costs, then actually doing a additional study is probably an investment worth making.
Absolutely.
It's great. Thanks for that. I've got a question from the floor from Jonathan Gorham. It's a question for Joe. How flexible is the mitigation? Yes, it's you, Joe. So, how flexible is the mitigation delivery? For instance, what would happen if the main contractor pulls out at the 11th hour?
Oh, well, it would be, hopefully it would be in your planning condition, it would be in the environmental management plan, which then would, in theory, be passed to the next contractor, whoever picks that up. So, and these documents are live that would be updated as the project goes along anyway, to allow for that flexibility. For obviously things change, not just in terms of kind of practicalities, but in terms of actually when you go out on site and do detailed SI or whatever, that you need to maybe have a degree of flexibility in the wording of some of the measures to allow for that.
Smashing, thanks, Joe. Well, I hope that answers your question, Jonathan.
Hopefully.
I had a very nice message from Claire Proctor, who said, thank you to all the presenters and organisers. It's been another hugely inspirational, informative, practical and useful webinar from a PhD research student perspective. So I would echo those comments. I think it's been a very interesting morning. In fact, it's done my summing up for me. But all I would say is thank you very, very much to our speakers for what's been an inspirational, informative, practical and useful webinar. Now, really, in all seriousness, I think it's a subject that, in the interests of leaving everybody wanting a bit more, I do think we need to do one on this mitigation thing, because I think that's another layer. And I certainly would like to propose that we have a stab at that and try and cover that next time.
And I'll keep throwing it in at every opportunity. Even though it's some way away, don't forget about biodiversity net gain. It's going to hit you like a lake for Fulby 2 if you're not careful.
Yep.
Watch out for that net gain, guys. And and again, thanks to all our speakers. Thanks to everybody who came. I hope you've enjoyed it, and we'll see you all again very soon. Cheers.